Mr Deputy President, I'd like to put this significant reform in some context. For those of us who are on the committee into the partial defence of provocation, there were some important events that have framed the law in this area, and these events are worth noting. Mr Deputy President, it was in 1982 that amendments were made to Section 23 of the Crimes Act. These are the last time that amendments were made. It is therefore some 32 years or thereabouts since this section of the Crimes Act was reviewed by this chamber. The 1982 amendments were preceded by a 1981 report by the New South Wales Task Force on Domestic Violence, which was established in the wake of a number of high-profile cases involving women killing their partners after enduring years of domestic violence and subsequently being convicted of murder, which at the time attracted a mandatory life sentence. And I'll repeat that. At the time, the conviction for murder attracted a mandatory life sentence. The report of the New South Wales Task Force on Domestic Violence recognised the inadequacy of the homicide defences in their application to women who kill intimate partners, and the then-Ran government subsequently acted in 1982 to amend the Crimes Act in several ways. Firstly, the definition of provocation was broadened to remove the requirement for a sudden response to provocative conduct and thereby account for cumulative provocation over time. Second, the amending Act removed the mandatory life term that applied to convictions for murder. In addition, the 1982 amendments also reversed the onus of proof of establishing the defence of provocation from the defendant and placed it onto the prosecution. Although not explicit in either the pre-1982 statutory formulations, the position in New South Wales was that the onus of establishing prosecution up until that time lay with the defence. The law of provocation, as I've indicated, has not been amended since the 1982 forms, which were designed to give effect to the widespread community demand for a modification of the law of homicide, particularly the law affecting what may be called crimes of domestic violence, including the reform the law relating to provocation. Mr Deputy President, the next matter of some substance is in 1995, because of developments that were occurring at that stage, the then Attorney-General Jeff Shaw QC established the Working Party into the Homosexual Advance Defence. The Working Party was established following the case at first instance of Malcolm Green, who had killed his friend Donald Gillies. The murder had been particularly violent, with the accused Green striking Mr Gillies at least 30 times and then stabbing him in the face at least 10 times. The argument or the defence put forward by Mr Green was that, in essence, the deceased Donald Gillies had made a non-violent sexual advance which justified the subsequent brutal attack upon him. The Working Party's report was delayed because the case of Crown and Green worked its way through the various courts. It was finally in 1997 that the High Court dealt with Crown and Green, a decision that by a narrow majority allowed Green to rely upon provocation in the form of the non-violent sexual advance. It was therefore in 1998 that the Working Party handed down its report, which recommended, amongst other things, that what can be described as the homosexual advance defence be abolished. That's 1998. Regrettably, for reasons that remain unclear, the government of the day ignored this recommendation, and the homosexual advance defence has been available to other accused since that time. And as no doubt may be referred to in the various second reading speeches, what that therefore created was in a sense a signal, one might say an implicit indicator that the law accepted that a non-violent sexual advance could justify the killing of another human being. I might now turn to more recent events, and more particularly to 2000.
Order.
As I indicated, I was turning to 2009, and more specifically to the murder of Manpreet Kaur. And this was a murder that was committed on the 29th of December of that year. I'll not relate all that occurred, but I will read from some of the sentencing remarks by His Honour Chief Justice McClellan, who said this in his sentencing remarks. It is plain that on the previous day, that is the day prior to the murder, the offender had formed a view that his marriage was likely to come to an end and that he needed to take some steps to protect himself, or otherwise he may be without a place to live and without any money. He would lose his entitlement to remain in Australia. His Honour said, I accept the offender's evidence that the events of the last 48 hours of the deceased's life, that is his wife's life, heightened the offender's concern about his position. Ultimately being told that his wife had never loved him and was going to leave him, accompanied by the offensive remarks of the deceased's brother-in-law, was the trigger for the offender losing his self-control. The acts by which the offender killed his wife were violent. It could only be described as a ferocious attack. The evidence from the autopsy, which I accept, was that he first strangled her, although that may not have been the cause of her death, and then cut her throat at least 8 times. At least 2 of the cuts were deep and would have led to a fatal loss of blood. Indeed, might I add, they did cause a fatal loss of blood, and Manpreet Kaur died on the floor of her home. Mr Deputy President, the circumstances surrounding that death were indeed shocking, and I think to some in this chamber were known very shortly after the event, and therefore the trial was in a sense eagerly anticipated. The trial did not take place until May and June of 2012, and sentencing took place on the 7th of June 2012. Mr Deputy President, you may remember in a sense the community outrage that followed the decision of the jury to acquit Mr Chamanjot Singh of murder and instead substitute a verdict of guilty of manslaughter on the basis of provocation. What the signal of that decision was that there was in some way a justification for men to kill their wives when they're told that they are no longer going to be in their same bed. One cannot imagine a worse signal to send in our community, that simply because a relationship ends, that in some way justifies a brutal murder such as this. One might think if it had only been one murder that occurred over the years, that one would be incapable of putting this aside, that one would be capable of saying, well, it's just one of those things. But unfortunately, as we know from the work of the committee, is that verdicts such as this have happened time and time again over the decades. Time and time again, men have used the excuse for killing their wife, that the wife wished to leave them, that the wife was having an affair, that the wife really didn't find the husband satisfying in bed. It really is an indictment upon our community that we have allowed that to occur. The resolution of this House that was moved by the Honourable Helen Westwood on the 14th of June 2012 was an opportunity for this House to review the law in this area. One should not in any way think that the decision of this House to deal with this matter somehow arose in the 7 days between the sentencing and the resolution of the House. There were many in this House that were alive to the problems of provocation, both with regards to the killing of domestic partners, but also in regards to the homosexual advance issue that I've already referred to. These are matters that some in our community have agitated for years. And sadly, we have been deaf, we have been negligent in our duty in dealing with these issues. I wish to congratulate the Honourable Helen Westwood for bringing the resolution. It was an important resolution, I think, for her, like the other members of the committee. This is one of the crowning moments of our time in this House. This is a substantial and significant change. And I will, in that context, say the way that the members of the committee worked together, ignoring our political affiliations, indeed even being prepared to ignore, to an extent, our own preconceptions as to how we should deal with this issue, I think is demonstrative of a capacity to work towards a common good at times. We did good. We did something worthwhile in that report. And we compromised to try and encourage the government to get to a position that they could not ignore the report. And I know it's easy for some to say, well, look, therefore we compromised and therefore what we came up with was a wrong decision. It was a compromise that worked. It was a compromise that forced the government, encouraged the government, might I say, into a position of listening to us, mere members of this place, mere backbenchers. We have achieved, or we are achieving, a significant change in the law in an area that has not seen a change in the law in 32 years. Now, it goes without saying, and I'm sure it will be a matter of debate in this House, that of course the proposal that now comes forward is different from what we recommended. And I think in terms of the debate when we go into committee, I will deal with some of that. But I will say this in regards to it. The model that we sought to adopt was based upon the model that was developed by the UK Law Reform Commission. And we did that for a number of reasons. We looked at other models, and one can see that from the minutes, that we tried various options, and each of those options we sought to road test. You know, the Secretariat took it away and tried to work out how it would have impacts in various areas. It was a very intelligent and thoughtful way in which we sought to proceed. But we came down with the UK model, and although we did do some twists in it, and I will make an observation with regards to that, because the UK model sought to get away with the need for a loss of self-control. But the UK model had one factor which we chose in the preparation of our report to delete. And that was a precondition that in terms of that model, that a considered act of revenge could not be, was excluded conduct. We chose to exclude that, and it actually changed the model. And I have to tell you, that was why the government has proceeded another way, because without the exclusion of a considered act of revenge, what essentially we open up is the possibility that people will react to horrific conduct by the deceased, but not in a sense out of passion, but out of a considered act of revenge. And I'll only give you one example of that at the moment. A heinous crime is committed, and of course we all talk in terms of sexual crimes, but I'll talk in terms of another one at the moment. In the early 60s, the President of the United States was driving along in a car, and a gentleman in the book depository by the name of Lee Harvey Oswald shot him, killed him, blew his head off. That caused considerable angst in the American community, and of course it led a few days later to Jack Ruby going into the basement of the police station and shooting Lee Harvey Oswald dead. I think if you took a poll on people in the United States at that time as to whether that conduct of Jack Ruby was justifiable, I think he would have perhaps actually won office in the United States for having taken Lee Harvey Oswald out. If you use the UK law reform model without an exclusion of a considered act of revenge, then somebody like Lee Harvey Oswald, Jack Ruby, could have relied upon our defence of provocation. It was a determination to kill because the conduct of Lee Harvey Oswald was so provocative, so grossly out of the ordinary in killing the President. So, in a sense, what we did when we adopted our model was we made the mistake. We considered the exclusion of a considered act of revenge, and for reasons that perhaps we can't go into, we excluded that element, and we perhaps, well, we did. We made the model an ineffective model. So I put that on the record now because we will have to deal with some amendments, and I have to say the position that is adopted by the government is not a position that comes about simply because they want to do something different from what we recommend. But they road tested our model in the same way that we had, and found that there was a big hole in it, and therefore they have gone quite extensively and in a very considered way, and sought to produce a model that achieves what we intended to do, but in a slightly different form. So there is no mystery in this. There is no desire to simply be perverse. This is an attempt to do the right thing by this government, and I believe they have come up with a pretty good answer. Could I conclude my remarks by saying this? I obviously have thanked all members of the committee who have participated in it, but again I would like to thank the Honourable Fred Nile for all that he did in keeping us under control in the committee and steering us to a particularly good result. As I said, for the Honourable Helen Westwood, this is a crowning glory. I say the same to Reverend Nile. This is a significant moment. It is a substantial piece of law reform. It may not be the crowning glory, but it's a biggie there on the mantelpiece, in my view. Can I also thank the determined efforts of the Premier with regard to the backing of this process throughout. The assistance of his office, the coordination that was provided in getting us to this point has been very significant. I am personally grateful for that, and I'm sure that all the members of this House are equally grateful for what he has done. I will conclude my remarks and come back when we go into the committee. Thank you, Mr. Deputy.
Further